The day I found concrete curing on my land was the day I realized the HOA president didn't believe in property lines, only power. I live at the edge of our subdivision, where manicured lawns slowly give way to open acreage. When I bought the house 3 years ago, I made sure of one thing: a full professional survey. Stakes were driven deep. Boundaries were mapped. Copies were filed with the county. Because land, to me, isn't just dirt. It's leverage. The problem started when the new HOA president moved in next door. She was the kind of person who introduced herself by handing out printed rules. Perfect posture. Perfect smile. Clipboard always nearby. Her driveway curved dramatically toward her garage, except the curve didn't quite fit. Anyone with eyes could see it. The concrete arched just a little too wide. Just a little too generous. And that little crossed 6 feet into my property. I didn't notice at first. Construction trucks came and went while I was at work. Forms were set, gravel dumped, rebar laid. By the time I walked the boundary after a weekend rain, the fresh concrete had already been poured. I stood there staring at it. My grass was gone. In its place was smooth, wet cement reflecting the sky. At first, I assumed it was a mistake. Contractors misread surveys all the time. So I walked next door and knocked. She opened the door like she'd been expecting applause. "Oh, you like it?" she said before I even spoke. "It improves the whole street's aesthetic." I told her calmly that her driveway was on my land. She didn't blink. "No," she replied, smiling tighter now. "The HOA approved the extension. We checked everything." That was the moment I knew this wasn't a misunderstanding. It was a test. I told her I had a certified survey. I told her the stakes were still in the ground. I even offered to show her the county map. She waved it off. "The HOA's architectural committee reviewed it," she said. "You must be mistaken." The arrogance wasn't loud. It was quiet, controlled, confident. That kind of confidence only comes from someone who believes they'll never be challenged. I walked back home and pulled out my file. Survey copy, property deed, county parcel map, tax record. The line was crystal clear. 6 feet of reinforced concrete sat squarely on my land. Now here's what most people would do: storm over, threaten lawsuits, call lawyers immediately. But I've learned something about power. You don't swing first. You document. The next morning, I photographed everything. Wide angles, close-ups, the survey stake beside the fresh concrete edge, time-stamped images. I even measured the encroachment on video. 6 feet, 3 inches. I sent her a certified letter that afternoon. Polite, direct, factual. Her driveway was encroaching. She had 14 days to remove it. Her response came through the HOA's attorney. Not her. Not an apology. A letter stating that the driveway fell within adjusted community improvement allowances. In simpler words, they were betting I wouldn't fight. And that's when I realized something important. She hadn't just built on my land. She had used her position as HOA president to approve her own violation, which meant this wasn't just about concrete. It was about authority. 2 days later, I attended my first HOA meeting. She sat at the front like a queen holding court. When public comments opened, I stood up and calmly announced that the president's new driveway encroached on private property and that formal notice had been given. You could feel the shift in the room. She smiled. "Oh," she said lightly, "that's being handled." Yes, it was. Just not the way she expected. Because, while she believed HOA approval overruled boundaries, I believed in something far more permanent: county records. And in 14 days, the concrete wouldn't be the only thing breaking. 14 days passed. No jackhammers. No apology. No attempt to correct the encroachment. Instead, I received another letter from the HOA attorney implying that the matter was under review and that any hostile action on my part would be considered a violation of community harmony guidelines. Community harmony. That phrase almost made me laugh. There's something uniquely bold about someone pouring concrete on your property and then warning you about harmony. But this is where most disputes go wrong. People escalate emotionally. They threaten. They post online. They rant in meetings. I did none of that. I hired a licensed surveyor to return and re-verify the boundary, this time with updated markings and a formal encroachment report. Bright orange stakes went in. Painted boundary lines ran directly through the center of her driveway. It was no longer a debate. It was geometry. The surveyor documented everything: GPS coordinates, county plat overlay, measurement depth, setback violations. The encroachment measured 6 feet, 3 inches at its widest point, and tapered to just under 4 feet near the garage entrance. That detail mattered, because partial encroachments are still encroachments. When the surveyor finished, he looked at me and said something simple. "She's going to have to remove it." That afternoon, I sent a second certified notice, this time attaching the updated survey and encroachment documentation. The tone remained calm and factual. "Remove the encroachment within 10 days, or I will pursue formal remedies available under state property law." No threats, just procedure. 3 days later, I got my answer. The HOA called an emergency board meeting. Not to fix the driveway, to vote on sanctioning me. The accusation? Harassment of the HOA president. I attended. When they opened the floor, I brought printed copies of both surveys, county maps, and the attorney's letter. I asked one simple question. Does HOA approval override recorded property boundaries? Silence. Even the board members shifted in their seats. The president, still perfectly composed, responded that the driveway had been reviewed in good faith and that minor boundary discrepancies were common in development. Minor. 6 feet of reinforced concrete isn't a rounding error. At that moment, I realized something critical. She believed her position insulated her. She thought the HOA badge functioned like armor. But HOA authority stops at private property lines. And she had crossed one. After the meeting, 2 neighbors quietly approached me in the parking lot. One admitted he'd had a similar issue with landscaping encroachment, but didn't want to fight it. The other said, "She's been pushing limits since she took over." That confirmed what I suspected. This wasn't an accident. It was a pattern. The next step wasn't dramatic. It was procedural. I filed a formal demand for removal through a property attorney. Not a lawsuit yet, just a notice of intent. The letter was clear. Failure to cure the encroachment would result in legal action seeking removal, damages, and recovery of costs. Now here's where things shifted. Because once attorneys become involved, ego becomes expensive. Her third response dropped the confident tone. The letter claimed there may have been a misinterpretation of boundary data and requested mediation. Mediation is what people ask for when they realize they may lose in court. I agreed, but on one condition. The driveway would remain and used over the encroaching section until resolution. The next morning, orange cones appeared blocking the outer curve of her driveway. Neighbors noticed. Suddenly, what had been quiet concrete became visible conflict. And visibility changes power dynamics. She couldn't host guests easily. Her vehicles had to park tighter. The visual embarrassment of cones cutting off part of her luxury driveway sent a message the HOA couldn't spin away. But I wasn't done documenting. I ordered a property appraisal assessing loss of land use value and potential structural damage from removal. Because once concrete is poured, removal isn't gentle. It fractures. And fracture costs money. By the time mediation was scheduled, I wasn't walking in angry. I was walking in prepared. Because destroying a driveway isn't about revenge. It's about enforcement. And in mediation, she would learn something she hadn't considered when she poured that concrete. Power in an HOA meeting is temporary. Property lines are not. Mediation was scheduled for a Tuesday morning in a quiet office park 20 minutes from the subdivision. Neutral room. Long table. Coffee no one touched. She arrived with the HOA attorney. I arrived with my surveyor's updated report, the appraisal, and a property rights attorney who specialized in encroachment disputes. The mediator began with the usual tone: calm, neutral, solution-oriented. Let's see if we can resolve this amicably. I was open to that. But she wasn't there to resolve. She was there to preserve control. Her opening position? A permanent easement. She wanted me to grant legal access to the portion of land under her driveway, in exchange for a small payment and goodwill recognition from the HOA. In other words, make the theft official. I declined. Calmly. Then her attorney pivoted. They suggested a boundary line adjustment, essentially redrawing property records to legitimize the driveway placement. That suggestion told me everything. They knew they were wrong. But they were still betting I'd choose convenience over principle. My attorney leaned forward and laid out the numbers. Removal cost estimate, substantial. Concrete demolition, land restoration, regrading, possible damage to adjacent foundation sections, attorney fees, survey costs, and, because the encroachment was willful, approved by the HOA president for her own benefit, punitive damages were now on the table. The room changed. You could feel the temperature shift. She tried one more tactic. This will create tension in the neighborhood, she said. You don't want to be the person who tears up a driveway. There it was. Social pressure. Reputation leverage. The assumption that I cared more about perception than property. I responded with one sentence. I care more about precedent. Because if she could build 6 feet onto my land and get away with it, what stopped the next expansion? A patio? A fence? A retaining wall? Encroachment unchallenged becomes permission. Mediation ended without agreement. 3 days later, my attorney filed for injunctive relief in county court, requesting a judicial order for removal of the encroachment. Now things were no longer political. They were legal. And legal moves faster than people expect when the evidence is clean. The judge reviewed the survey documentation and issued a preliminary order. The encroaching structure must be removed within 30 days unless a settlement was reached. No ambiguity. No HOA language. Just a clear directive. That's when the neighborhood truly noticed. Because once heavy equipment permits were pulled, word spread. An excavator was scheduled. Concrete saw crews were contracted. Utility markings were flagged. She tried one last maneuver, filing a motion to delay on grounds of community impact. Denied. The court didn't care about aesthetics. It cared about land. On demolition day, the machinery arrived just after sunrise. The crew chief reviewed the boundary markers carefully. Spray paint lines traced exactly where the cut would be made, a clean separation along the surveyed property line. Neighbors watched from porches. Phones came out. Whispers traveled. The first cut of the concrete saw echoed down the street. There's something final about that sound. Concrete dust rose into the air as the blade sliced through reinforced slab. Section by section, the encroaching portion was segmented. Rebar snapped under hydraulic force. Chunks were lifted and hauled into dump trucks. She stood at the edge of her lawn, arms folded tightly, saying nothing. No clipboard. No authority. Just a homeowner watching consequences unfold. The process took 6 hours. By mid-afternoon, the outer curve of her driveway was gone, leaving a squared-off edge stopping precisely at the boundary line. My land was dirt again. Scarred, but mine. But here's what she hadn't calculated. Demolition didn't just remove concrete. It exposed grading issues beneath. Because her driveway had relied on that overextended curve for structural balance. And when it disappeared, so did part of her drainage flow. When the dust settled, literally, the driveway looked like a badly trimmed haircut. Clean cut at the boundary line. But uneven. Awkward. Incomplete. What the demolition crew uncovered beneath the removed section was worse than I expected. Her contractor hadn't just poured over the line. They had graded soil toward my property to support the slope of the driveway curve. When that support vanished, the remaining slab lost part of its drainage path. Water doesn't negotiate. It flows wherever gravity allows. And now, without that outer arc, rain began pooling along the cut edge. The first storm came 3 days later. I watched from my window as runoff collected near the seam where concrete met fresh soil. By morning, muddy water had tracked back toward her garage. Not catastrophic, but not functional either. That's when her contractor returned. Not to apologize. To assess damage control. They proposed installing a retaining edge and new drainage trench, entirely on her side this time. But here's the problem. The original driveway had been engineered with the illegal extension in mind. Removing it meant redesigning the remaining structure. And redesign costs money. A lot more than a proper survey would have. 2 weeks later, she applied for a permit to rebuild the edge correctly. The new design was narrower, less dramatic, less grand. Also, $28,000 more expensive than the original build. Because retrofitting always costs more than building correctly the first time. The HOA tried one final play, quietly floating the idea of shared aesthetic compromise to smooth tensions. A landscaping buffer.
Decorative stone along the line.
Something symbolic. I declined. Symbolism doesn't repair soil compaction or legal precedent. Meanwhile, something interesting happened inside the HOA. Board members began asking questions. If the president approved her own encroachment, what else had slipped through under architectural approval? An internal audit was requested. Not by me, by them. And that's when the second wave hit. Turns out, there were multiple small adjustments in recent months. Fence heights exceeding guidelines. Patio extensions nudging setbacks. Minor but consistent. Authority without oversight becomes convenience. And convenience becomes abuse. Within a month, a special board vote was scheduled. She resigned before it happened, officially citing personal reasons. Unofficially, she knew confidence had evaporated. But here's the part most people miss. Destroying the driveway wasn't the victory. Restoring the line was. My land was regraded. Fresh topsoil laid. Grass reseeded. The boundary markers remained visible, deliberate, undeniable. And something else changed. Neighbors started double-checking their own surveys. Property lines that once felt theoretical suddenly mattered. Because when someone pushes 6 feet and gets stopped publicly, it resets expectations for everyone. The financial aftermath didn't end at demolition. Her homeowner's insurance denied coverage, labeling the situation a self-created encroachment. The HOA declined reimbursement, stating the approval process had been misused. So the full burden fell exactly where it belonged. On the person who chose to pour concrete across a legal line. Every time she pulls into her squared-off driveway now, the missing curve is visible. A permanent reminder that authority doesn't override ownership. You'd think that after 6 hours of concrete cutting, a court order, and a very public driveway amputation, the street would go quiet. It didn't. It got careful. There's a difference. About 3 weeks after the demolition, I noticed something unusual across the road. A neighbor was planning a patio expansion. Lumber had been delivered. Spray paint marked the grass. But before a single shovel hit the dirt, a survey crew showed up. Bright vests. Tripods. Measurement poles. They weren't guessing. They were verifying. That's when I understood the real impact of what happened. This was never just about one driveway. It was about precedent. When people believe rules are flexible for those in power, boundaries blur. But when someone enforces a line publicly, calmly, legally, without theatrics, the entire ecosystem recalibrates. The HOA appointed an interim president shortly after the resignation. First order of business? Reviewing architectural approval procedures. No more self-approvals. No more vague community improvement allowances. All exterior projects now required third-party survey confirmation if they approach setback lines. They didn't announce it as reform, but everyone knew why it happened. Meanwhile, my reseeded lawn began to fill in. Grass grew where concrete once cured. The soil settled evenly. The property line stakes remained in place longer than necessary, intentionally. A visible reminder. One afternoon, the former president approached me while I was checking the irrigation system. No clipboard. No attorney. No tone of authority. Just a homeowner. She didn't apologize. But she did say this. I didn't think you'd go that far. That sentence told me everything. She assumed resistance would stop at complaint. She assumed social pressure would override enforcement. She assumed convenience would win. It didn't. And here's the part most people misunderstand about situations like this. I didn't destroy her driveway. The court order did. The survey did. The decision to build beyond the line did. I simply refuse to accept the idea that authority replaces ownership. That distinction matters. Because when conflicts turn emotional, people frame them as revenge. But this wasn't revenge. It was restoration. 6 feet, 3 inches. That's all it was. But lines aren't measured by length. They're measured by principle. Over the next few months, neighborhood dynamics shifted subtly. Conversations became more measured. HOA meetings became less theatrical and more procedural. Even disputes that had nothing to do with me were handled differently. Documentation first. Discussion second. Assumption last. And that's the quiet power of enforcement done correctly. No yelling. No threats. No viral spectacle. Just documentation, deadlines, and due process. If you're wondering whether I regret escalating it to court, I don't. Because had I accepted a permanent easement, that 6-foot strip would have been a visible surrender every time I stepped outside. Instead, it's grass again. Level.
Defined.
Undeniably mine. So, here's the real question. When someone builds on your land, whether it's concrete, policy, or pressure, do you argue loudly? Or do you enforce quietly? Because power built on assumption collapses fast. But power built on boundaries? That lasts. And on this street, the boundary isn't just a line in the soil anymore. It's a standard.